Good morning, you guys. Look, I'm coming on here to do this early this today because I am agitated and having some effects of my procedure. So, I'm not in my 100%. I think I have the nausea under control, but I still have some pain. But I want to clarify some things. And I titled my live, They Just Can't Tell It All, because when someone analyzes your work, they don't ever tell it all. They tell the pieces that they want to tell to fit the narrative that they want to create. They don't ever tell it all, right? They leave and omit things because that's what makes better commentary for them, right? And so I want to come and tell it all, but I'm going to tell it all in a way where I do a Q&A with Google because that seems to be like a useful tool for some, right? So I did a little Q&A with Google to ask certain questions to find out, am I being disingenuous because or intellectually dishonest, because I think that my examination of the things that I said in my last couple of lives is actually intellectually honest. Um, I'm applying the law to a situation. Everybody knows I'm a true crime buff. So when I'm looking at cases, I'm looking at cases according to the examination of the law. And yes, I do have my own opinion, but I'm looking at what the attorneys are presenting, all of them, what they are saying, and I'm determining whether I believe one or the other. I'm never all on one side. But I do have an opinion, and that opinion is going to be on what I think is the side of right. Just like the people who have their opinion based on the side that they think is right, right? And rather than them just focus on that, they have to deflect by adding all of these other adjectives in, right? Preservatives, I guess, are meant to preserve their commentary. I'm just having conversation, okay? So that's all it is for me. It's this true crime is a hobby for me. If people look at my channel, they will see that true crime is a hobby for me because I talk about crimes of all kinds of people. I highlight all kinds of crimes, right? A few weeks ago I presented a case where with Lindsay Whitestone or White House or something like that, where she's a woman out of I can't remember what state she's out of, but I'll go back and get it and attach it to this live. But she has been charged in a similar style to the RSK trial. She was tried in the state court. They didn't like the state outcome, and the prosecutor recommended it to the federal. And now she's being held in federal detention without bond for a crime of transporting the child across state lines for the purposes of sex. It's not a RICO, but the behavior is the same. It's not a RICO because she didn't have a group of people that she could employ to do this. It's not a RICO because um, she did not collude with a whole bunch of people in order to organize this, but she was charged in the federal with the same exact crime that she was charged and found guilty. She pled guilty in the state. The DA was not satisfied with the verdict, so the DI recommended it to the feds, and the feds picked the case up, and she's charged and being detained. I mentioned this case weeks ago, right? So when I'm looking at true crime, I'm looking at it from the vantage point of I have my opinion on who I think is innocent and who I think is guilty, who I think did it and who I didn't think did it. I'm willing to evaluate evidence once the case is displayed. I'm likely to change my mind when I see a case displayed. Um, Even if I feel like someone committed a crime, but I feel like the prosecution did a poor job putting on a case, I will admit that. So I don't think it's anything dishonest about what I'm saying. I'm being honest. But since people have, I guess, accused me of that, I am going to do a Q&A with Google about the things that were mentioned so that we can see what Google has to say about it. I am giving a answer based on what it looks like when this is presented in the court of law and how it can look to a certain jurors like me. There might be jurors out there like some of you. Of course, I believe there are. That's why I believe that some cases don't have the outcome that I would to see and assess it with, because all the jurors don't think like me. But I am a juror that thinks like me, and I happen to think that I do have a solid foundation for my belief system, okay? And what I believe when I'm evaluating and assessing cases. To me, the R. Kelly case is another true crime case. It is of no consequence to me. I don't take it personal. I'm looking at what was presented and I'm being a trier of fact when I look at the case. Being a trier of fact means that you come to the conclusion that both sides could be telling some lies, but you're going to sift through the evidence like wheat to determine, was the burden of proof met? Did they prove the case? And it just so happens, in my opinion, on the RSK trial, in both situations, New York and Chicago, I believe that that actually happened, right? Now, I've also mentioned previously in lives that if let's separate the cases, because it seems like everybody brings these cases together as if it's just one big case, and they apply rules to different cases. And this is why I mentioned about when Lady D was saying she was confused by what the defense did, because the defense actually did exactly what happens out here, but they did it as a strategy. I understand why they did it. It was a strategy of why they did it, right? And I'm going to speak about that in a minute. It was a strategy why the defense has the people confused about these two cases. But this is exactly what they want to happen out here. They want the people to see these two cases as combined and not separate them apart, so that then they can believe that injustice was done on both cases, right? Because they want them to apply all the standards across the board. So I had mentioned previously in the past, and I say this also. Let me first stop real quick and say this. I am a centrist, okay, on everything. I don't believe all of nothing one way or the other. I'm going to examine information and come up with my own decision and my own conclusions based on my own findings, not on someone else's, right? That's not my style. I just don't work like that, right? And so a lot of times I think out here people tend to want to try to throw you into a box or into a column because that's what suits their narrative. Now, what's interesting about that is that they don't want to be thrown into one, but they do it to others. And they do it when others don't agree totally with their position, right? But God forbid somebody throw them into a box or put a narrative on them that doesn't fit, right? So, but now let's go back, okay? So, when I'm examining these cases, like I said, I'm examining them from the lens. If I'm a juror and I'm going to listen to, this is why I said don't put me on the David case, because I've already made a decision on the David case. And I'm honest. I'm not like some of the other people out here that are going to say, I would get on the case and knowing that I already have made a decision. And then I'm going to use my already made decision and going into the courtroom to say, okay, I don't care what none of the facts are. I'm going to make a choice. In the David case, I've already made a decision. So hey, Michelle, how are you? So if I was called as a juror on that case, I would immediately put all the things I need to check off on the box in the columns that need to be checked with the questions that are being asked so that I could be exempt from the case. But if that didn't work, if once I appear in person, I would definitely let them know, yes, I don't, in that case, based off of what the prosecutors have submitted in the brief, based off of the information I know because I followed this case from when the girl went missing, those things are so consistent that I don't believe that I can have a different view. I don't think I can look at the facts. If something different comes out about that case, I will be absolutely shocked. But I know that I am hard on my opinion when it comes to that case. Hey, good, Just V, how are you? I have a little bit of pain, but I wanted to get up and clear this because I heard Calla last night, girl. He was over there with Skylight. So some of my commentary, I'm just responding to some of the things that Skylight said because I'm assuming she was responding to my live, especially because there was one particular thing that she mentioned about me saying something about the R. Kelly supporters and his health, right? So that's what gave me an indication she was responding to me. But the first part of my statement did refer to another content creator who tried to lump me into a column or a group. And it's interesting because they don't like that done to them. And so reciprocity is like important, okay? That's important. So that's what I asked to be treated with reciprocity. I have not said anything disparaging to throw a person into a group or a column that I feel like they have. Hey, you guys, I'm sorry. Um, okay, can you guys hear me? I have not done anything to throw anybody into a column, and I would expect the same thing. Nobody's heard me state that I'm throwing myself into a group, into a bracket. What people have heard me say is that I'm a centrist. You've heard me say I'm a true crime buff. You see on my page that it is reflective of that. So when I'm looking at these cases, I'm looking at these cases with an opinion, but I'm also trying to apply what I see the legal team going, the direction the legal team is going in. You saw we all of them together. They only see supporters versus everyone. Exactly. I mean, it's sickening. It is actually sickening. And it's honestly, I think it's the stumbling block that keeps them from seeing where they might be in error. Like, it's a hubris that they won't allow them to admit that they might be in error about some things because that's how they categorize things. They can only categorize things at extremes. And it's kind of sickening, right? So first I want to address when I mentioned in the name calling, like it's always the name calling, right? Too, you know. But anyway, so I want to address the issue of what I mentioned about the inmate, and I want to explain what I meant by that because that was taken completely out of context, and that portion of what I said could have been taken out of context because I didn't stay on it. I didn't give any explanation to it. I just mentioned it. So back when all of these allegations, when Bo Burnley initially entered this motion, and all of these allegations were thrown out of all of these things that the government did in order to try to sabotage R. Kelly, right, and target R. Kelly. Um, there were statements made about R. Kelly having blood clots. Not one time did I say he doesn't have blood clots. I didn't never said that. Nobody never heard me say that. What I did say was that I expressed my concern that if his legal team was truthful in what they alleged, right? And later on, since it has come to this, I didn't do this, but I can't right now. I don't have time because if I went through all of it now, then it would take me a very long time, and I know that my pain tolerance probably can't take that. But I am going to go through some of the examples of what I mean about Bo Brinley's defense style and how he defends his clients. I have them. I'm going to give the example. So when I'm making and I'm saying this, I'm not basing this just off of how his movements are with R. Kelly. I'm basing it off of things that pertain to other cases that he has tried and things that he has done. He has been reprimanded on the local, state, and district level by all types of judges. He was the subject of a case, of a prosecution that he skated by with the skin of his teeth. So when I'm making an assessment on what I'm seeing him do in this case, it is because I've looked at other details surrounding his style of defense, right? So, but I want to focus on this thing first with the blood clots. So I never said that it was a lie. What I said was that Bo Brinley, when he hurled these accusations out, he stated that he was going to go through every extent in order to get his client back into the hospital. We saw that that never happened. Where did he go? To the hole. He went from the hospital to the hole. We didn't see Bo Brinley put not in one piece of paperwork to request an injunction for the judge to step in and to do something about getting him to the hospital to get the surgery that he needed. Bo Burnley publicly proclaimed that he was going to get the paperwork and provide it to the public. He never did that. And to me, as a supporter I would think that the supporters would be concerned. Now, I did hear at times Lady D expressing concern and asking more questions and asking when is Bo going to come out and give a health update. But it seems like that the Kel supporters generally, because I'm not saying all of them, because there are lots of them that don't even speak. And those are the ones that I was speaking to when I said the other day about I'm concerned about how some of this information, when it goes out, how it plays on their vulnerabilities and their support, right? But none of that was discussed. None of the things that I gave concessions to on the other side, from my centrist point of view, were discussed in the analysis, right? But generally, and within that group, they can lay blame to the prison that they say are denying care to R. Kelly, but they did not demand of the person who represented R. Kelly to provide them with the necessary updates to know that R. Kelly's health is okay. Because if his health is not okay, then all of these other requests and all of this other legal bullshit that's going on don't mean anything. Because if something happens to him, none of that relief is going to be of any help to him in the end. So I would think that the health issue should be the number one priority, and that the demands for the legal team to do all the necessary things in order to try to get him back into the hospital to have this life-threatening surgery that we were told about, that should have been the priority. That should have been the top at the list. And there are things that his attorney could have done in order to get him placed back into the hospital for emergency surgery. The BOP is not the final determinant. The judge can issue an injunction. So I asked Google a question. I said, can an injunction be issued for the prison to send an inmate back to hospital for a life-threatening procedure? Just so that people can know that my answer and how I felt about it is not disingenuous. The response says yes. A federal or state judge can issue an emergency injunction, such as a temporary restraining order, to compel a prison to transfer an inmate to an outside hospital for a life-threatening health procedure, provide specific strict legal standards as met. To successfully obtain a court-ordered medical transfer, you must prove that prison officials are acting with deliberate indifference to a serious medical need under the 8th Amendment. For convicted individuals, and the 14th Amendment for pretrial detainees. The law requires the following. The need is serious. You must have documentation from a doctor showing the procedure is medically necessary to prevent severe harm or death. Officials are ignoring the need. This is number 2, bullet number 2. You must prove that prison staff and medical providers are aware of the life-threatening risk, but are consciously ignoring it, delaying care, or providing severe and inadequate treatment. And emergency legal action. Because a life-threatening situation requires your attorney to file a motion for the restraining order, here's what you need to do. The burden of proof. The court will need to see rapid medical deterioration or imminent irreparable harm, like the threat to permanent injury or death, if the inmate does not receive the hospital procedure immediately. Speed. If granted, this forces the facility to take the inmate to the hospital right away, or risk being found in contempt of court. So there is a legal remedy. There is a response. There is a consequence. So it says immediate action steps. If an inmate is currently facing a medical emergency inside a local, state, or federal facility, the immediate action is to secure all doctor's notes, diagnosis, hospital recommendations regarding the necessities of the procedure. How do we know? Wait a minute. That's not it. It says submit the grievance. If the situation allows for it, file an emergency grievance, but do not wait for the long appeal process if the situation is life-threatening. And then it says contact outside advocates for assistance navigating the local prison system, such as local facilities. Reach out to organizations like the American Civil Liberties Union or Prison Legal News to seek legal referral options for civil rights and prisoners' rights attorneys. Right? So there was nothing dishonest about what I said about that. If he was experiencing a medical emergency, the immediate need should have been his health. And this is just my opinion. I feel like that should have been the first main focus, because without that, none of the rest of the things that people are talking about even matters. And so for the fact that his attorney did not do that and allowed him to go from the hospital to the hole, and he told people, he came public and told the people, had the people worried about the health of the person, of the individual. And then he comes back and provides no update, and that's accepted. But what's not accepted is that the hospital took him back from the hospital and took him back to the jail and put him in a hole. And they are under the assumption that he's dealing with this serious medical condition. That's not accepted. But the person who is the advocate and working on his behalf, there's no stress put on him to do something about the situation. And so to me, that is where I say that the care was displaced. That's just my opinion. The focus at the time was displaced. Yes, you want to deal with all of the other legal things that Bo Brinley alleged in that motion, but the health scare is the most important thing, because there are people who were really out here worried about the health of this man and what was going on. And this attorney never came back and gave any follow-up about the care of the person. That is what makes it look suspicious to me. That is the base in which I find suspicion. I'm not just saying it because I said it. I'm suspicious of it because for that reason. I'm not saying that he doesn't deal with it, that he hasn't in the past. I'm not saying that his age cannot be a contributing factor to him dealing with it. I work in healthcare, so I take it very serious. That's why I take this issue serious. Just like everybody else has their buttons that can be pushed when it comes to things that they know and they are involved in and they know about. And then when people aren't responding appropriately, it is a cause for concern for them. That's what that is to me, because I am a healthcare worker. Not only am I a healthcare worker, I'm somebody who deals with cardiovascular issues. So I take these things very seriously. I'm just coming off the cusp of having to be my own advocate in a medical situation that was being ignored, and I'm not in prison. I just mentioned a case in Fulton County where a man was legs was amputated and his fingers was amputated because of neglect from the jail, from the facility. So my advocacy is not straight across. My advocacy is situational. Just because a person is an inmate, and even if I feel like they committed a crime, it doesn't mean that I think that they should be just left to die like a wounded animal. Like this system here has to give basic human dignity standards in these facilities. And even if I feel like people are guilty, I feel like that should be met. I did a whole live about the Fulton County Jail. Met people in there, how they were being treated. I made a whole live about one of the defendants in the YSL trial, about how he was taken from the hospital and brought to testify. Like, so my concern for, even if I think people are guilty for their medical care, it's going to always override everything. To me, that's the most important thing. None of the rest of the stuff matters if the man dies from not having the life-threatening surgery that his attorney came out here and told us that he needs. And that attorney got off the hook, not having to come out here and provide anything, any update to that situation. Everybody let him off the hook. They didn't let the jail off the hook, though. They didn't let the BOP off the hook. They let his attorney, who could have stepped in and proven to his supporters at that time what kind of advocate he was for this person. But he did not. He failed, and he failed in my eyes. And I feel, it's my opinion, that the people who support allowed him to fail it. Right? They allowed him to fail it. So I want to go to this first, because the next thing, because this is something that I always highlight. So the blueprint in relation to this type of RICO charge, it goes back much further than what people give credit for it. But I understand that they are applying it to celebrity status, right? And so that's why in their mind, they believe that the blueprint came from the R. Kelly trial, right? I could go through several circumstances of people who are not known and show you where the same things have happened to them, but nobody cares about that. And the reason that nobody cares about that is because it's not a celebrity. So the same way that people get accused of having an interest in this case because this is a celebrity involved, it can be applied evenly across the board on the other side, because there are lots of people who have faced the same situations as R. Kelly, and there's nobody speaking up about that. I have provided several different examples in several different ways throughout my time posting and giving commentary on how this happens, but nobody listens to those because they don't listen to it because it's not R. Kelly. I understand the topic in the conversation here is R. Kelly. And so that is the thing that most of the people are paid attention on. But I think that that's fair to say across both sides. It is not fair to say one side is only focused on this because this person is of celebrity status and you don't apply it to your own team as well. It is the same thing, because there are lots of other people who are going through similar situations and nobody is stepping in to advocate for them, right? So I always mention this, and I posted this on my board weeks ago, probably over a month now, about Keith Raniere. And Keith, I said this to the other day. And within the African American community, we oftentimes accuse African Americans and other people of only wanting to highlight Black crime, right? And we criticize them for that. The problem is that when people are talking about, when people of color that do commentary or news reporting or whatever are talking about other crimes, it is not that other people are talking about it. It's that a lot of times people of color show a disinterest in it. They're not interested in crimes that are discussed people of a color and ethnicity, right? And so unless it rises to a higher celebrity status, or unless it will prove their point of what they're saying about the main thing, right? So that is one of the reasons. So I always talk about Keith Raniere because Keith Raniere was the founder of NXIVM. NXIVM was a self-help organization. It had, I believe it had religious status. I forgot what the heck the thing is called, but they have religious status. So you can almost liken it to like a Scientology. Okay. Now, I've been watching that case too. That's something that I think is important for people to watch. I don't know why that man, Maskovich, has not been prosecuted yet. I know there are lots of people who are working on it. And I know several people are filing civil lawsuits to try to get discovery so that they can try to see if they can get some criminal prosecution in relation to Maskovich. This is the same formula. That's what I'm saying. If people will go outside the box, they will see that these formulas and these steps are happening. The reason they don't see it is because they spotlight one topic and they're not looking at how these things are happening across the board, across ethnicities, and how these things are being built. But some of them are happening in real time, and some of them have already happened. And Keith Raniere happens to be one example. And Keith Raniere's case was prior to R. Kelly. His case was prior to R. Kelly, okay? And I'm going to read to you guys what Keith Raniere, I Google, because Google is our friend, right? That's what people like to do to get information. So Keith Raniere was the founder of the NXIVM self-help organization. He was convicted by a federal jury in Brooklyn on June 19th, 2019. That's my daughter's birthday. Of all 7 counts of superseding indictments. He was subsequently sentenced to 120 years in prison. 120 years in prison is what he was sentenced to. This was what he was convicted for. He was convicted for, now this is a one-man RICO. This is a one-man RICO, June 2019. Keith Raniere. He might not be popular within the African American community, but let me tell you, he had a backer of Seagram's. The heiress of Seagram's was financing his organization. He had a huge following, and he was picked up and indicted in the midst of his documentary being created. So the documentary released soon after his arrest because the documentary and information from the documentary probably is what led to the investigators getting that information from before that and then leading to the arrest. They didn't want to wait on the arrest, right? These people were coming forward producing this documentary, okay? And so He was convicted of racketeering conspiracy. This involved multiple underlying crimes, including extortion, identity theft, and the production and possession of child pornography, sex trafficking, attempted sex trafficking, and sex trafficking conspiracy. He was found guilty of exploiting and grooming vulnerable women, operating a secret sorority, and sexual servitude. Forced labor. He coerced followers into unpaid, grueling labor while isolating them from their families and threatening them with blackmail. Wire fraud conspiracy. Used to maintain control over followers and illegally acquire their resources. This is what Keith Raniere was charged with. You said, and the Seagram's granddaughter went to, I think, but she didn't go to trial with him. She was convicted. But she was not charged in the RICO. She had 2 other charges, and it was outside. Yeah, you're absolutely right. It was outside of him. So similar to how in Chicago, how they got Brown and McDavid, but it was outside of that RICO, and this is why I separated, because Chicago wasn't a RICO. You said, I think it was, yes, yeah. She got, fraud, and then she had another charge with immigrants because they were bringing immigrant women, or they were dealing with immigrant women or something like that. So one of her charges was related to the immigrants, and the other one, I think it was fraud. Yep. And she was tried in a whole separate case. Okay. So, but she never once testified against Keith Raniere. She never, I'm not testified against him. She never turned against him. She never turned against Keith Raniere. To this day, there are people who say that she still believes that Keith Raniere is what he said he was. So more than likely, just like those Charles Manson ladies, she's willing to go and give him some more money probably, because she's never turned her back on him, right? So this June 19th, he was convicted on June 9th, 2019. He was arrested prior to that. This happened before R. Kelly. I know within the African-American community, even across some pop culture, it seems like R. Kelly is the bigger star. What I'm saying to you, there is still another huge figure who this happened to directly before R. Kelly. There are other people that this happened to. I talked about Malachi York, another African-American who was with the Nuwabian. I can't never say Nuwapian. I can't never say that name right. But he was convicted. He was given 138 years in prison. Same charges. So when I'm coming and I'm saying that there is a challenge in trying to say that there's a sentencing disparity in the R. Kelly case, what I am doing is looking at cases, not some of popularity, some not, but looking at cases where people are charged with the same things that he was charged with. They by far have way more time than him. So the issue that you end up having in court is having to prove that there was a disparity, because what the prosecution is going to use is they're going to use instances like this and many others. These are just 2 that I gave you, but they're going to use instances like this and many others where they looked at the sentencing guidelines, and for the same charges, these people got way more time. That is why I'm saying it is going to be a difficult hurdle. These are the kinds of cases that you have to try to look at in order for you to try to look at to try to prove that there is some type of sentencing disparity, right? So, and this is just, I'm saying this specific to the New York case, because I'm going to pivot in a minute into the Chicago case, because I know how to separate them and not make them the same. And it's one thing that I tried to do, especially because this conversation for us, I guess at this point again, rolls back up due to Rashona Ramphay's release of her book, right? First, the allegation came out about Bo, and then Rashona's book released. And when Rashona's book released, all hell broke loose around here because the narrative did not fit what Bo was alleging at the time, right? And so this is why I present these kind of cases, because these are the hurdles and the challenges that you're going to have. This is the thing that the defense needs to be looking at to try to see if they can find a sentencing disparity based on his ethnicity, based on his celebrity status, or things of that nature. The court isn't going to look at the celebrity status when evaluating the sentencing disparity. They are going to look at cases that have been charged similarly, and first they're going to look at all of the things that were done in the sentencing, during the sentencing hearing, and then they're going to then use cases like this one, and even cases of people who are unknown, which is why I say this is another reason why it's important to know what is happening to people who you don't deem important, because those are the things that then they will use in order to say there is no sentencing disparity. That happened to P. Diddy when Mark Agnifilo went into court trying to get bail for him, and they were trying to use the race card and use that this has never happened to this is only happening to him because he's a black man. The prosecution came with cases where they could prove this has happened to lots of people that were not of color that had the same charges. They didn't use only celebrity cases in order to prove this. They used all of the case law that applied to the situation to support what they were doing. So that is another thing I wanted to clear the air about. Okay? Now give me 1 second. Hold on. Okay. Because I told y'all I asked Google some questions. So I'm using that to make sure I stay on topic, because I know I'm not going to survive long. Let's see here. So there was a mention about the Giglio material, right? And I think this is left up to each individual to in their heart make the determination, because I think this is where this matter really ends at the end of the day. So yeah, they had to demand. So the responsibility of the government, I guess, was to do the investigation, and they did the investigation. In their investigation, they are saying that they yielded that no attorney-client privilege information was breached, that it was personal information. However, of course, in the defense's motions, in Bonjean's motions, she is alleging that some attorney-client privilege information was breached. And I could be wrong, but Angie, because she has this ability, she can correct me if I am. The main reason for them having standing in order to request this motion in the first place is that really the allegation of to request the information is the allegation of the potential attorney-client privilege information being breached. Okay? And this is the reason why. You don't have a Azriel Clary, a Angelo Clary, or anybody else involved in this situation coming forward saying that we're willing to testify on the behalf of the defense that you don't have Azriel saying that she was persuaded by this. She's the witness. You don't have her saying she was persuaded by what her father showed her from Tasha K. Right? So that would be one thing that I would think maybe would help the defense. I don't know. I really don't know how much, because Azriel was named in the indictment prior to her cooperation, or at least that is what is presented. Prior to her agreement to cooperate, she's named in the indictment. And the proof that I want to provide in relation to that is Joy. There are videotapes of Joy that were admitted into evidence. Joy wasn't there. She wasn't listed into the indictment. Like, the idea that you have to have a victim visible to and there to testify and hinging everything on that, and that's going to help the client get off, that's not a surefire way to really go about something if you want to get away with something. Like if you make it so that the victim is not accessible or is not there to testify, or you've done something to alleviate the victim, so now you can't be prosecuted. There are two cases. The one we just saw, and these are murder cases, but we just saw two cases, one in Detroit, one in Florida, where no body was ever found on a victim. Both of those individuals, one of them was convicted of murder, the other one eventually ended up pleading guilty to murder, right? No body was found. They didn't have a body to go with the crime, but one was prosecuted and convicted. And I believe he was convicted to death because he's in Florida. The other one pled guilty in the 11th hour. And that's the one that we've been reviewing, his called Jarvis Buzz. You said nobody's case happens. Exactly. A lot. In addition to this, when it comes to child cases, and this is going to segue me into separating the Chicago case and the New York case, because I have said on several times that so many people have issues and they try to make those issues with the New York case apply to the Chicago case. And it's just my opinion that you really have to separate them out because they are two different beasts. They want to make them together. And that is what the defense job is to do, is to make you think that these cases are together. But in my opinion, they are separate, and I'm going to give my reason why. And I don't think it's an illogical reason, right? I don't think it is. Other people might think that it's illogical, but I think if people were being honest and examining it, they would be able to see it. And the reason why I say that is because sometimes it's just the speaker. When they hear certain people say certain things, they can be willing to agree and meet and go with it. When it's a certain person, they're never going to hear it. They're going to always think that it's some bias. They're going to always categorize them and try to dismiss what they're saying, right? And so you have to separate these cases out because for this reason. When you have situations with child pornography, it is oftentimes you don't have a victim. That is often. It is one of Bo Brinley's other cases, Josh Duggar. I don't even have to go far to give an example. Josh Duggar, he is working on Josh Duggar's appeal. Josh Duggar was downloading child pornography of unidentifiable victims. They don't care that they don't have the victim there to come testify in court. He was convicted. And I think a lot of times, like I said, because the Black community is often siloed, and when they do pay attention, there are lots of people out there like me, but I'm just talking about generally speaking, because they are siloed off and not looking at crimes like this as it pertains to, and they don't stretch themselves out to look at these crimes. That's why they don't see how these things are going and how these type of crimes are being targeted. They are targeting people who are not just producing child pornography, directing child pornography, selling child pornography. They are arresting people who are downloading and watching child pornography. And these people don't have any attachment to the victims in the pornography. They don't even know them. They don't even know them. They are unidentified victims. And so this is one of the main reasons why I say, okay, for those who have issues with the New York case, let's look at the Chicago case, because the Chicago case involves child pornography. Now, the other thing that they like to conflate with this case is this one tape, this one sex tape that was released back in the early 2000s. Right? And make it seem like that's the only tape that the prosecution had to proceed with in its prosecution. And this is why they continue to look at it like double jeopardy, right? But that is far from what is true. It is not even something that Bonjean even attempts to argue at any point. I know what you parts of the law that don't go with the narrative, they're dismissive of it, right? So in a pretrial hearing, when Bonjean and the other attorneys were arguing this piece of evidence in relation to this sex tape from the early 2000s. It was a ruling, and it was determined that that video would not be allowed to be shown to the jury. That the only purpose of that tape was in relation to the obstruction charge. And that is how it could be presented. Bonjean and I believe Bo Brinley, I don't know if Bo Brinley gave much argument in that, because I think Bonjean took the lead on it and he probably just agreed with most of what she was saying. And then Brown's attorney. But it was determined by the judge that that video would not be shown to the jury. So in the prosecution's opening statements, they explained to the jury, you're only going to hear about videotape number 1. And it only relates to these particular charges. So they are given, and the tone is set at the time of the opening statement, what that tape is for. What fails to be looked at is that there are 3 other produced tapes with whole totally different scenarios and additional individuals added. This is where the other victims come from. And this is the part that they refuse to talk about. This is the part that they refuse to deal with. And that's the thing that I'll speak to when I'm saying what I'm saying about the case. That this involves a child pornography case. Let me separate what happened in Chicago. Let me separate the fact that the RICO is trivialized, right? That people on all sides, they have their opinions about what happened with the RICO. Let's look at this Chicago case, and let's consider that this Chicago case was about child pornography. And people keep minimizing the Chicago case. I don't. The reason I don't minimize the Chicago case is because I have watched tons of cases involving child pornography. And there is something key that Judge Levin-Weber says in his sentencing when he gives his sentence on the child pornography case in Chicago, right? A lot of people want to talk about that he didn't believe them, so that's why he went light on the sentence, blah, 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 blah. Of course, he considered all of the things that Bonjean submitted in the sentencing report, or her part of the sentencing report. I think she did a hell of a job with that. And I don't think she gets half of enough credit for what she did in New York or what she did in Chicago, right? And these are things I've been saying. But you never hear this stuff said when you hear, but this is anybody. The opposing side is always going to focus on the things that they don't agree to create their narrative or craft their narrative. I've been saying all of this, right? So I believe that Bonjean worked the hell out of that New York pre-sentencing report. And I believe that that is what got R. Kelly only 30 years. And I'm saying only 30 because I'm comparing it to what I know other people with those charges then received. And that is what is going to be the measuring stick. That's the metric. That's why I'm saying that. Right? So you have I'm sorry, y'all, it's some cleaning, so y'all might hear some other stuff going on. So that's the metric stick that I'm using when I say this, right? So Jesus Christ, what you have to that's what you have to consider across the board. I'm sorry, I'm trying to, this shit is distracting. So I don't think that Bonjean gets half the credit that she should get for the job that she did in those pre-sentencing reports, right? With the mitigating factors. She did a hell of a job that got him where he was. But there is something that Judge Levin-Weber says in his sentencing of R. Kelly in the Chicago case. Judge Levin-Weber says that if it was not for the conviction that he received in New York, he would have given R. Kelly more time. He would have given R. Kelly more time. People are dismissive of that statement. They don't want to pay attention to that statement. But he is saying, I would have given R. Kelly more time. Meaning, if the New York case did not exist, and mind you, the New York and the Chicago case were both indicted in the same month, if I'm not mistaken. If not, it might have been only weeks apart, but within the same month. But Judge Levin said, if it were not for what he received in New York, I would give him more time for this case. And it is because someone like a Josh Duggar, who just watch, I'm not minimizing it. I'm just saying this for the sake of looking at the charge, right? And that's what I mean by how I view information. Josh Duggar downloaded and watched child pornography. In the case with RSK, we have him producing, directing, and then I think they said distributing child pornography. He additionally watched it. There's lots of testimonies talking about how he watched it because he critiqued it and then told his victims what they needed to do and not do in order to make a better performance the next time. So we already know for a fact that he watched the pornography that he produced. But in addition to him watching it, he was in it, he directed it, he produced it. And so those are steps much further than Josh Duggar. Josh Duggar has a minimum of 12 years in prison. So looking at, he has more years, but I think he's eligible. I think he has 20 years. He's eligible for parole in 12 years, right? But I've put a ton of cases dealing with child pornography, whether they are black men, whether they are white men. I have an abundance of white men cases on my community wall. I have an abundance of white female cases who are being charged with doing to minors what R. Kelly did with minors, that are being prosecuted and are facing more years than what R. Kelly got, or have been sentenced to more years than what R. Kelly got. And so these are the metrics that I'm using. This is what I'm saying. These are the hurdles that I'm saying are going to be difficult. And this is why it makes proving the point difficult. That's what when I'm speaking in a true crime way, right? This is the reality. This is what makes it difficult. When I spoke about them believing that the jury was tainted, you have to show some product of that, some evidence of that. You can't prove if the jury was tainted in one direction or the other. Especially in the Chicago case, you get a mixed verdict. How would same like with the Diddy case, you get a mixed verdict. So the verdict that agrees with their narrative, they all for, and they believe that was just. But then the verdicts that don't, the charges that they don't, then the jury. Well, you got to make up your mind. You got to make up your mind. Was the jury tainted or not? And that's my only observation of the situation. In the Chicago trial, you have a mixed verdict. In the Diddy New York trial, you have a mixed verdict. They still believe the jury was tainted, though, because Diddy was convicted of the Mann Act. There are still people who will tell you that. They still don't trust the jury. That is always going to be the thing. If the jury doesn't rule in a particular favor, that is what people are going to believe. And they are going to believe that it was some kind of outside influence that tainted the jury. And I talked about this, I think last week or the week before, when I said that it's interesting when I was talking about the David case. And I was talking about how Mark Geragos and Harvey Levin from TMZ were talking about the brief that was released by the prosecution. And they were saying that that brief was being used in an attempt to taint the jury pool. But then when information is being put out that is favorable for the defendant, and that's placed out and leaked out, they look at that as swaying. The language changes. I like to keep the language even. Either both sides are going to be attempting to taint the jury, or both sides are going to be attempting to sway the jury pool. I don't think it changes because it's one side or the other. I think that is a wrong application. I don't agree with that. And so I always say this, the center is a dangerous place because nobody likes to trust the people in the center because they feel like that they can be a Benedict Arnold. They're not a Benedict, they're telling you they're centrist. A Benedict Arnold is somebody who comes into your camp and pretends to be like one of you and then betrays you. No, if you're saying up front you are a centrist, that means that most of the opinions and the ideas you have are going to go down the center. And that's what people should expect. When I put Lady Justice, the scales of justice in the balancing act, I know that both sides have a prone to lie. I know that one side is prone to trump up charges, no pun intended, and the other side attempts to downplay the charges. So that's why you have a judge. You can have a bench trial or trial by jury because you need a decider of fact. Those individuals who are going to sift through all of those sides and come to a conclusion. That's why our system is set up that way. So I'm not gullible or naive or trying to deny that that is the case. I've on my channel spoken about times when I think that the government possibly was involved in impropriety. So I'm in no way trying to suggest that the government can't do anything wrong, but in particular scenarios that are handed down to us, I'm saying where I'm more likely to believe one over the other because of what I see, because of what's in front of me, not because of I have this preconceived opinion and it's going to be that no matter what. You said another thing. I don't think that people understand that nude pics of your underage girlfriend is still child pornography. It's not just weird white men looking for pics. Exactly. Exactly. Just that's what I'm saying. Like they are not looking at the seriousness of this, what they are doing with cracking down on child pornography. There is an abundance of white men being arrested and they are being sentenced for lots of years. Stephen Stearns, that killed Madeline Soto over in Florida, he had a whole separate case because of the child pornography on his phone. That he could have got the death penalty for that. So when I'm looking at 20 years on the federal level for that versus someone who commits a same crime and can get the death penalty in Florida, like that's what I mean by you gotta show that this disparity is there. I know in the eyes of the people who see it, they think they see that, but you have to stretch out a little bit more and look at what is going to be helpful. And if you, while searching out for what's going to be helpful, if you find something different, you have to be honest to say you found something different. That's my only point. That's my only point is that you have to be honest. So when it comes to the Giglio, I think Bonjean has gotten some information. I think some of the information the defense feels like they did not get because the information that they feel like they didn't get doesn't meet the standard that they requested it for. And it's that they believe that there was some attorney-client information breach and whatever they received did not have that. And so to them, they feel like that information is incomplete because they don't have that. And how I come to a conclusion that I don't believe that there was any attorney-client privilege that was breached or available is because of how this defense strategy pivoted, right? So it pivoted. Okay, so let me first say this. If there was any reason that Jennifer Bonjean thought that the materials, and she's been still trying to, I guess, fight to get materials as it relates, or was at the time, I don't know if this is still her thing to do now, but she was still trying to fight thinking that there's going to be some attorney-client privilege information revealed through this discovery. But if she thought that, I believe in my heart that she would fight tooth and nail for it because everything you've seen Bonjean do has been about procedure. Even when you see her when it comes to other cases that she's had, it's been about procedure. When she knows that she has a bad client, and what I mean by bad client is she knows that the client did the things that they said that he did or she did. she looks to those things in order, the loopholes, in order to try to find it. And based on everything I've seen her do, I've seen her trying to turn over the table, trying to get certain evidence excluded. She was very creative about how she went about doing that stuff. So I don't think for any second, if Bonjean really was hard bit that it was attorney-client privilege information breached with that BOP situation, that she wouldn't be fighting for that, right? But the thing that is saying to me that there was nothing yielded from that is because of Bo Brinley's pivot, the strategy. That this is how I'm coming to my conclusion, right? And like I say, and I mean not conclusion, but my opinion, because my conclusion won't be until we know all things to be known, and that may be never, but this is where my opinion sits now. See, I think with the issue is the other side, they want people to accept everything they say for fact. These are my opinions, but I'm giving some factual base for how I'm arriving at my opinion. So, Bo Brinley picks up the Chicago case and he attempts to use an attorney client situation in order to try to deal with a new trial, right? He doesn't pick up from where Bonjean left off. He crafts and creates a whole new scenario that gives us testimony of the breach of attorney-client privilege being extracted illegally and from a totally different person. So he doesn't even mention in his motions that the BOP, he mentions the violation of his communications, but he does not focus on that the BOP officer is the one who um who got this attorney-client privilege information and handed it over to the prosecution. No, they create now a whole nother character who enters the story. And he is the one who is now testifying and saying, I took the attorney client privilege. No, the BOP officer didn't extract it from whatever system that they originally alleged that it happened. They are saying that now this roommate, Mondi, physically took this information from R. Kelly and he gave it to the prosecution, and that this was in coordination with the prosecution, right? Let me get out of this because I have a question for Google on this one. Let's see. That's the wrong one. Because I had a question. Okay. So this is why I believe that the belief amongst the legal team between Bonjean and Bo Brinley are consistent that there is no material or no documents or no evidence that shows that there was attorney-client privilege information in the discovery they received from the breach of the BOP officer, because Bo Brinley doesn't stick on that. He goes a whole different route, and now there's a whole another character that enters the picture that now is saying, I took it. So now it creates the question of the breach of attorney-client privilege information. They've created something tangible for that, right? What in the world? Hold on one second, you guys. Why did that go to that? It must have. Okay. Hold on one second. So I asked Google as soon as it comes up. Oh my goodness, my stomach. I hope I don't gotta go back and come back in. Hold on, you guys. Hold on, I gotta get some pain medicine. Hold on 1 second. I really want to try to finish this because I really want it to be understood where I'm arriving, how and the framework that I'm using. I'm not going by the same framework that supporters and non-supporters are going by. I'm coming from a framework of somebody who watches true crime. That's where I'm coming from. Hold on. Goodness gracious, you guys. I'm sorry. Uh, yo, they put this thing on stent. I got a stent. I did not know this thing was gonna be like this. Um. Okay, I fixed the connection. So what is? Oh, you want to know what? For some reason, my Xfinity might be out. Give me 1 second. Let me Give me 1 second, you guys. Let me try to hook up to my home Wi-Fi because I think it might be something. Wait a minute, it's saying connected to that one. The backup. It might be something going on in the area. Hold on 1 second, so I can connect to my hotspot. Hold on. Oh my God. Mm. guys, this new motion is nothing but a scheme cooked up by Flower Pot. Yeah, I don't know who cooked it up, but I know that this attorney has this reputation. You guys hold on 1 second, okay? Because I'm having a little bit of difficulty. Hold on.